Witnesses, oh, they're all here now. Thank you. Thank you for the hard work you put into this to bring this issue to Senate's attention. I want to give a quote. It just can't be right that one district judge can stop a nationwide policy in its tracks and leave it stopped for years that it takes to go through the normal process, end of quote. Those words are from Justice Kagan, said during a speech 3 years ago. I happen to agree with her. Our hearing today goes by the title of, quote, Rule by District Judge 2, Roman numeral 2, exploring legislative solutions to bipartisan problems of universal injunctions. I hope that we can continue the discussion from our hearing on the same topic in 2020 and focus on some legislative solutions. For a number of years, but particularly the last few months, we've seen increasingly sweeping orders from individual district judges that dictate national policy. These orders, quote unquote, called universal injunctions, direct the government to take or not take action with respect to persons who aren't even before the court. Although our founders saw an important role for the judiciary, they didn't design a system that made judges national policymakers. They adopted a constitution that strictly limited courts to exercising power of the words that are in the Constitution to cases or controversies. Sweeping universal injunctions defy nearly 2 centuries of historic precedent. For the first 175 years of our history, universal injunctions were unheard of. They've been extremely rare until the last decade. Now we can barely read the news without learning of another district judge issuing an order that covers all 93 judicial districts in the country. It's one thing for a district court to offer relief to parties before it. That's what a judge can and what a judge should do. A judge has authority to resolve a case or controversy, and sometimes that'll include holding that a statute or executive action is unlawful. It's another thing, however, altogether for a single judge to order the government to act with respect to people who aren't even before the court. That reaches far beyond the legitimate authority of the court and becomes policymaking. This is something none of us, Democratic or Republican, should want judges to do. Right now, there are more than 600 active district judges, more than 1,000 if you count senior judges. Any one of them can effectively veto national policy. In one sense, district judges wield more power than any Supreme Court justice who must vote with their colleagues before stopping or compelling national government action. This creates then a strong incentive for form shopping. According to 2024 Harvard Law Review study, nearly all universal injunctions against the first Trump administration and the Biden administration were issued by judges appointed by the opposite political party. This places tremendous strain on the judicial system. Universal injunctions are also unconstitutional. Article 3 of the Constitution tasks the judicial branch with deciding, as you've heard me say, cases or controversies. The Supreme Court has long required judges to engage in detailed analysis to ensure that they have authority over a case. They must determine that a party before them has been injured, that the inquiry is traceable to a defendant's conduct, and that the court can do something to remedy it. Now, judges routinely ignore these constitutional limits and issue orders directing government action for the entire country. In February, a district judge issued an order requiring $2 billion in U.S. aid funding to be paid out within 36 hours. The vast majority of people who never even sued. The Supreme Court had to instruct the district court to narrow its ruling and narrow it significantly. On Monday, a district court in California issued an order in a case involving 7 Venezuelan plaintiffs and an association that advocates for them. Instead of just deciding the case before them, the judge halted the policy for approximately 350,000 Venezuelans under the Temporary Protective Status Program. The district judge had no authority over people who weren't before the court, but single-handedly vetoed a policy that Americans specifically elected President Trump to enact. Some people may ask, if universal injunctions are eliminated, how can plaintiffs get relief, especially in cases where it's hard to represent every person affected by law or order? The federal rules of civil procedure provide a solution: class action. This is a powerful legal tool to offer comprehensive relief, and it also contains protections to preserve the rights of parties that are represented in this unusual way. Universal injunctions shortcut all of that. Eliminating universal injunctions still preserves the important role of the judiciary in a system of checks and balances. Class actions remain intact, and judges retain their awesome power to protect litigants before them from unlawful action. But when a single judge can override the political branches to set national policy, the checks and balances of our country and Constitution are thrown off. We should instead return to the framework established under the Constitution. District courts decide the case before them. The appellate courts set precedent for all courts below them. That's the appropriate check on other co-equal branches of government. Universal injunctions turn the whole thing on its head. Most of us in this room have at various times supported or opposed universal injunctions. My fellow Republicans and I sometimes like them when there's a Democratic president, and my Democratic colleagues probably like them right now, even though they criticized them a few months ago under President Biden. Too often, we accept politics over principle. But the truth is that we all know this isn't how government and the judiciary should operate. It's past time to address this issue. The Supreme Court can and should fix this problem. Unfortunately, they sit on their hands. If they won't act, Congress must act. I propose legislation to fix this problem. I think it's a good solution because, like all good compromises, it probably leaves everyone a little unhappy. We all have to agree to give up universal injunctions as a weapon against policies we disagree with. The damage it causes to the judicial system and our democracy is really too great. I hope today we can have a productive discussion about how to solve this problem that has plagued and frustrated Democratic, Republican presidents alike. I'm going to introduce now our two majority witnesses, and Senator Durbin will introduce the Democrat. Professor Samuel Bray is a John N. Matthew Professor of Law at Notre Dame. He's a leading expert on law of remedies and the law of equity, and he's been cited by many Supreme Court justices, including Justices Thomas, Gorsuch, Kavanaugh, and Jackson. He's also been cited by both the Trump and Biden administrations. Professor Bray has written extensively on the topics of universal injunctions, including his Harvard Law article that goes by the title of Multiple Chancellors Reforming the National Injunction. Professor Bray is an elected member of the American Law Institute and is an advisor on the restatement of torts remedies. Jesse Panuccio is a partner at Boies, Schiller, Flexner, and co-leader of the firm's appellate practice group. He previously served as acting Associate Attorney General at the Department of Justice. Before that, he served as then Governor Rick Scott's General Counsel. He's also a member of the Administrative Council of the United States. I'm very interested in hearing both of your remarks today, and thank you very much for coming. And now, Senator Durbin.
Thanks, Chairman Grassley. I want to thank you particularly for a comment you recently made where you said, quote, "You can't impeach a judge just because you disagree with their opinion," end of quote. It shouldn't have to be said, but I hope every member of this committee will make that equally clear today. Indeed, in our nation's 250-year history, a judge has never been impeached because a president disagreed with that judge's ruling. But we do need to say so loudly and clearly, as you did, Mr. Chairman, as President Trump and co-President Elon Musk have demanded the impeachment of federal judges who have ruled against the administration. House Republicans have rushed to kiss the ring, so far filing articles of impeachment against 6 federal judges and counting. The dangerous, irresponsible conduct of the president and his allies has resulted in a disturbing, truly disturbing, increase in threats against our federal judges and represent an existential threat to judicial independence. During my time on this committee, I've met with several judges whose lives have been threatened simply because of their service on the bench. Some of these threats have turned into acts of violence that have taken the lives of judges' family members, including spouses, parents, and children. It affected my state in the Northern District. I've said it many times before in this committee, and I want to say it again here. Violence or threats of violence from the right or the left on the political spectrum are never acceptable. When I was chair of this committee, I repeatedly condemned threats against Republican-appointed justices and judges, and we passed bipartisan legislation to improve security for the bench. We must speak with one bipartisan voice on this issue. Last week, my staff spoke with several judges about judicial security. Every single judge said exactly the same thing. The threats have become more frequent and more disturbing. And while these judges were careful not to comment on political issues, they noted that recent rhetoric against judges has contributed to increased threats to judicial security. One judge likened it to adding fuel to a bonfire, and she noted her fear that in time it would become a wildfire out of control. We must avoid that outcome, but it will require the president and his fellow Republicans, including members of this committee, to work together with the Democrats to lower the temperature and end the attacks on judges and judiciary. This hearing is about nationwide injunctions. It's impossible to separate the hearing from President Trump's record in office. The reality is that we would not be holding this hearing if the president took a different approach to the rule of law. We've heard repeated complaints from Republicans about the number of injunctions issued against this president compared to other presidents. Why so many? They ignore the fact that this president has issued more than 100 executive orders. the most by any president at this point in his term in at least 4 decades. Many are clearly illegal. Take the president's executive order to end birthright citizenship. 3 federal judges in 3 different states have blocked this order, including 2 judges appointed by Republican presidents, and 3 separate appeals courts have refused to lift these injunctions. Judge John Kunar, who was appointed by President Ronald Reagan, was the first judge to block the order, which he called, quote, blatantly unconstitutional. The reality is that the number of injunctions issued against the first and second Trump administration are evidence of a president who is clearly violating the law. That being said, I'm happy to discuss the legal and practical implications of nationwide injunctions. But as I've said many times before, we cannot have one set of rules for Republicans and another set of rules for Democrats. Any legislation on this topic must be based on the merits, not political expediency. Professor Bray, in your testimony before the committee, recall a decision by a Texas court about 10 years ago on DAPA. That's near and dear to my heart. That is based on the DREAM Act, which I introduced a long time ago. And my pleadings with President Obama to create that program meant a lot to me personally. I recall when that issue came before the court in Texas, and the judge issued a universal injunction to enforce it. I would add, as the chairman has noted, there was cheering from the Republican senators from Texas for that decision. Some of them today see the issue differently in the context of a president of their own party. I cannot support legislation that does not take reality into consideration. Only if we have an effective date that makes sense would I consider making any changes myself. In 1776, in a pamphlet appropriately titled Common Sense, Thomas Paine famously wrote, quote, "In America, the law is king. For as in absolute governments, the king is the law. So in free countries, the law ought to be king, and there ought to be no other." Today, we'll discuss the use of nationwide injunctions, but there can be no debate that in America, the law is king, as it has been since our founding. The president is not a king, not even this president, as much as he might wish otherwise. He is bound by the decisions of our courts, just like every other American. Now, the president and his political allies are welcome to disagree with judicial decisions that block his illegal actions, but we cannot allow anyone to threaten or intimidate our judges. And we cannot stand idly by amid a threat to our Constitution and the separation of powers. The chairman has asked me to introduce my witness, and I'll be glad to do that. Professor Stephen Vladeck is the Agnes Williams Sesquicentennial Professor of Federal Courts at Georgetown University Law Center. I knew Mrs. Williams. He is a nationally recognized expert on the federal courts, the Supreme Court, national security law, and military justice. Professor Vladeck is also highly regarded as an appellate advocate, having argued several cases before the U.S. Supreme Court and over a dozen before various lower federal, civilian, and military courts. Graduate of Yale Law School and Amherst College. Thank you, Mr. Chairman.
Yeah, thank you. Would you please still rise for oath? Do you swear that the testimony you're about to give before this committee will be the truth, the whole truth, and nothing but the truth, so help you God? All of you have answered affirmatively. Please sit down, and we'll start with you, Professor Bray, and then Mr. Vladeck, and go across.
Mr. Chairman, Ranking Member, and members of the committee, I'm honored to speak with you today. What's wrong with the universal injunction has a policy dimension and a constitutional dimension. The ordinary way the federal courts work is that someone challenges a law in one circuit, and whether the challenger wins or loses, the decision of the circuit court will be a precedent for that circuit. Justice Kagan called this the normal process. It allows multiple courts to consider a question before the Supreme Court is eventually asked to resolve a disagreement. It takes some time, but not thousands of suits. This is how questions are supposed to be settled in the federal courts: deliberately, collectively, and with appellate precedent. But universal injunctions, with lightning appeals straight to the Supreme Court, have accelerated judicial decision-making, leading to rushed and suboptimal decisions. The universal injunction reduces the chance that multiple circuit courts will consider a legal question. It's an end run around class actions. It's an end run around issue preclusion. It's inconsistent with basic principles about the precedential authority of a district court. And it has an asymmetric effect. 100 people challenge a federal policy, and if the federal government wins 99 of the cases, it won't matter as long as one plaintiff wins and gets a universal injunction. The government has to run the table. These policy consequences are partly about the universal injunction and partly about how it interacts with heightened judicial polarization and extreme forum shopping. That's a point on which I agree with my friend, Professor Vladeck. He is right to criticize extreme forum shopping. He's right that challenges to the Biden administration in single-judge divisions were an egregious problem. Where I think he's wrong is to suggest that it would somehow be rash for Congress, at long last, to address the severe policy problems caused by universal injunctions. If I may, this is the fourth time that I've testified about these problems over the last 7 years. There's also a constitutional dimension. A final judgment binds the parties, and a court order must be followed. No one is above the law. But judgments and orders have this kind of authority in our legal system because of the principle that courts act as courts, deciding a case for the parties and giving remedies to the parties. Once a federal court decides a case and gives a remedy to the parties and the people they represent, there is nothing left for it to do as a court. There is no constitutional authority for the judge to go on and decide the cases of other people or to give remedies to other people not before the court. The universal injunction is emphatically not a partisan problem. Universal injunctions and vacatur are stopping almost every major initiative of the second Trump administration, just like all the Democratic and Republican administrations in the last 10 years. They are a bipartisan scourge. At any particular moment, of course, there is a partisan valence to solving the problem of the universal injunction. But that partisan valence will not last. There are no permanent majorities. In the long term, the real loser from the universal injunction is our democracy. The Republican or Democratic bias oscillates over time. What does not change is the universal injunction's built-in bias against any effective government action. A legislative solution should be laser-focused on non-parties. It should apply to temporary restraining orders and to vacatur under the Administrative Procedure Act. It shouldn't just put guardrails on universal injunctions. Only one proposed bill fits these principles, and that's the chairman's bill. This bill would take the universal injunction and bury it 6 feet under. No evasions, no circumventions, no substitutes, no outs for Republicans, no outs for Democrats. The federal courts are and should be a bulwark against unconstitutional or illegal actions taken by other government actors. They should hold the president accountable, regardless of whether the president is a Republican or a Democrat. But the federal court should perform that essential function as courts do, by deciding particular cases brought by particular parties with remedies that control the relationship between these parties. The last 10 years have seen a fundamental transformation of the relationship between the judicial branch and the executive and legislative branches. It is past time to reset that relationship.
Thank you, Mr. Chairman. Thank you for the invitation to testify before the committee. In my testimony, I'd like to make 3 points about how we got here and then offer some thoughts on the way forward. First, as Ranking Member Durbin suggested, any discussion about nationwide injunctions has to be put into the broader context of the unprecedented moment in which we find ourselves. Substantively, we have a president running roughshod over existing legal constraints to a degree we've simply never seen before. And procedurally, we have a Justice Department engaged in highly partisan and ethically dubious behavior in lower courts that we've never seen from lawyers working for the federal government. Even this committee seems to be of the view that the central problem in these cases is the relief federal judges are imposing, not the lawlessness they're imposing it against. At the risk of bringing data to a mud fight, the reality is not that a small handful of hand-picked judges appointed by Democratic presidents are using nationwide injunctions to thwart the executive branch. As of last Friday, the 46 cases in which district judges have blocked Trump policies have involved rulings by 39 different judges appointed by 5 different presidents of both parties, sitting in 11 different district courts across 7 circuits. That includes 9 cases before district judges appointed by Republican presidents, too. Many of those rulings have included nationwide relief, but not all of them. Against that backdrop, it seems to me that this committee should be especially careful not to react to underinformed calls from the president and his supporters, and rather to be focused on preserving the relationship between judicial independence and judicial accountability, rather than taking steps that might undermine it. Second, it's worth underscoring that federal courts have, in fact, long and routinely issued relief that benefits non-parties and or has nationwide effect. My friend, Professor Bray, already referred to vertical stare decisis alongside Justices Kavanaugh and Barrett. Even Justice Gorsuch, the most visible critic of nationwide injunctions on the Supreme Court, has voted in favor of them at least 11 times since 2020. More than that, any time a court invalidates a state or federal law on its face, rather than as applied to the specific plaintiffs, it is necessarily providing relief to non-parties, since the law can no longer be enforced against anyone. That's not only well settled, there's no serious argument that it's beyond the federal court's powers. And even nationwide injunctions have virtues that other forms of relief do not. Consider the birthright citizenship cases. Do we really think that parents should have to challenge that policy one child at a time? Would it make any sense at all, even on a broader scale, for the scope of birthright citizenship to differ in Arizona, New Mexico, and Texas simply because those 3 states fall into 3 different circuits? Of course, a nationwide class action could solve that problem, but it does not strike me as a coincidence that the rise in nationwide injunctions came shortly on the heels of the Supreme Court's evisceration of nationwide class certification. Chairman Grassley's bill alludes to class actions as a preferable vehicle. I could certainly endorse that idea, but tellingly it does nothing to make them more broadly available, even though Congress unquestionably could do so. Third, it seems to me deeply myopic to talk about the rise of nationwide injunctions without talking about shifts in behavior that have dramatically increased the impact of such rulings, several of which were already referred to by Professor Bray. Don't take my word for it, though. In the last 3 Supreme Court terms, we've seen 5 rulings from the justices reversing nationwide injunctions issued by hand-picked judges in Texas and Louisiana and affirmed by the Fifth Circuit because the plaintiffs in all 5 cases lacked Article III standing. There's no question that nationwide injunctions have been abused, but the abuses in those cases were not about the scope of the relief the courts were issuing. It's only exacerbated by it. And critically, those abuses would not go away even if nationwide injunctions were narrowed or eliminated. Meanwhile, the cost of eliminating nationwide injunctions would be less of an ability to restrain executive branch lawlessness at a moment in American history in which that power has proven singularly vital. So what is to be done? First, if the members' real concern is that the president should have the authorities that courts are denying to him, it seems to me that they could consider legislation to provide those authorities, rather than legislation that would prevent courts from fully and effectively enforcing existing legal constraints. Second, insofar as this committee wants to focus on procedural reforms, it should focus on reducing the ability of individual parties to manipulate the judicial system, not on limiting the ability of courts to hold the executive branch accountable, especially in an age in which Congress has proven less able to do so itself. Finally, if the committee's true goal is to improve the functioning of the judicial system writ large and not just to maximize short-term partisan political advantage, now that a Republican's in the White House, the committee could follow the model of other recent court reform legislation and have any reforms go into effect on or after January 20th, 2029. Otherwise, the message this committee would be sending is that its goal is to insulate an unprecedented degree of lawless behavior by the executive branch from meaningful judicial review, a message I can't imagine this committee wants to send, and one that the separation of powers, to say nothing of the rule of law itself, simply can't afford. Thank you again for the invitation to testify. I look forward to your questions.
Chairman Grassley, Ranking Member Durbin, and members of the committee, thank you for the opportunity to testify today. I note at the outset that the views expressed in my testimony are entirely my own and not those of my law firm or any of its clients or any entity with which I am affiliated. Today, the committee considers a recurrent problem in our federal judiciary. The propriety of non-party relief is a question at the heart of our constitutional republic. It is a question that asks whether our federal courts exist to decide cases or to advance causes. It is a question about a practice that renders every judge a king and every court supreme. The statistics show the issue is not confined to one president, one party, or a particular substantive policy. Accordingly, the Department of Justice, across administrations, has consistently argued against granting relief beyond the parties to a case. Just a few months ago, President Biden's Solicitor General explained that, quote, universal remedies are inconsistent with longstanding limits on equitable relief and the power of Article III courts and impose a severe toll on the federal court system, end quote. And jurists on both sides of the ideological divide have recognized the problem. As Justice Kagan stated in a 2022 speech, quote, it just can't be right that one district judge can stop a nationwide policy in its tracks and leave it stopped for the years that it takes to go through the normal process, end quote. Before I highlight the many problems with non-party relief, let me offer one concrete example. In 2017, the Department of Justice imposed new conditions on law enforcement grants, requiring participating local jurisdictions to cooperate with federal law enforcement to remove illegal aliens who had committed serious crimes. The city of Chicago sued, alleging the grant conditions were unlawful. The district court issued a preliminary injunction, but rather than stopping at providing this complete relief to the party before it, the court enjoined the grant conditions nationwide. Cases were pending in other districts, and Chicago could not make any claim that its own interests were required nationwide relief. Yet the district judge, with one line of dubious reasoning, exerted power over every other grantee in the country, including those who didn't want it and supported the conditions, and exerted power and precluded any other judge from effectuating a contrary conclusion. The Second Circuit Court of Appeals in New York would later find these conditions lawful, highlighting how incredible it was for a lone district judge in Chicago to dictate the result in New York and everywhere else. With that example in mind, let's just highlight a few of the problems with non-party relief. The first problem with non-party injunctions is, as Justice Thomas has explained, they are legally and historically dubious. The Constitution grants to federal courts the power to hear cases and controversies, which the Supreme Court has long interpreted as the power to render a judgment or decree upon the rights of litigant parties, not non-parties. Some argue that nationwide non-party relief is a necessary check on the ever-growing power of the executive branch. But the answer is not to fix one constitutional distortion by creating another. Rather, if the concern is with the power of the administrative state, then the answer is for Congress to reassert its atrophied policymaking muscle, not to transform the judiciary into a third political branch. The second problem with non-party injunctions is they undermine the norms, rules, and structures that undergird our multi-court, multi-jurisdiction, multi-tiered legal system. One such legal norm is the concept of percolation. There are several legal provisions and practices that reflect this preference for percolation, but I'll highlight just one, and it's the U.S. Constitution. It establishes one and only one Supreme Court and such inferior courts as Congress may establish. In this hierarchical system, one district court does not bind another and one circuit court does not bind another. It is only Supreme Court judgments that are binding on all federal courts. Yet nationwide non-party relief effectively has any of 1,000 district judges wielding the same supremacy as the Supreme Court by stripping from other courts the efficacy of their judgments. The nationwide non-party injunction thus simultaneously makes every court supreme and every court a potential nullity. The third problem with non-party injunctions is they are undermining public confidence in federal courts. History has shown the American people have a stubborn tendency to demand a say in the rules that govern their lives. Humility, then, is a necessary judicial virtue for life-tenured judges who have a share of the ruling power for life and cannot face elections by the people like the other branches. But in recent years, the third branch has lost all sense of itself. It will either rediscover judicial humility or lose the support of the people and force a national constitutional crisis. Because the Supreme Court appears unwilling or unable to rein in its own branch, it is time for Congress to act. 3 legislative fixes seem advisable. First, Congress should amend the necessary statutes to make clear that federal courts do not have the power to grant relief to non-parties. Second, it appears the latest trend in relief is for district courts to enter temporary restraining orders. Those should be made immediately appealable. And third, and finally, even if Congress enacts the above fixes, it is likely that judges who believe they have nationwide power will shift from granting non-party injunctions to certifying classes. Congress should consider imposing mandatory jurisdiction on the Supreme Court for any injunction or similar order that the Attorney General certifies as a national emergency. Thank you. I look forward to taking questions.
Thank you very much. We'll have 5-minute rounds for questions. I'm going to start with Professor Bray. One criticism has been leveled against the legislative solution that I've proposed. It's been that it undermines the judicial branch's checks and balances on the executive branch. Do you think this is a fair criticism, and how would you respond?
Thank you, Chairman Grassley. I don't think it's a fair criticism. I understand where it's coming from because the place of the courts as a check and balance on the executive branch and the legislative branch is very important in our constitutional system. But the way courts do that is by deciding according to the law in particular cases. And then that ripples out to other cases through precedent. That's the way they serve as a check, without fear or favor, following the law in the case. But they serve as a check, as courts do, by deciding cases, by giving remedies to the parties in the case.
Mr. Panuccio, you have direct experience in the Justice Department dealing with non-party relief ordered by district judges. From your perspective, how significant is the problem of universal injunctions to the relationship between the executive and judicial branch?
Thank you, Chairman. It's a great question. I think it's a very significant problem, and I think it is years of this practice are eroding the relationship between the Department of Justice and the executive branch and the courts, and I think that's happening across administrations. What effectively happens when a nationwide injunction is entered is that every single case, every single policy of the executive branch becomes an emergency that needs to move up the appellate ladder very quickly. And Supreme Court justices appointed by presidents of both parties have noted that the increase in the emergency docket is straining the court, it is straining its resources, and it is also reducing the quality of decision making. And so you are seeing increased friction. And even in these district courts that issue nationwide injunctions, I think you're seeing very unfortunate comments made by some of the judges. There is a real tension between the jurists and the lawyers, and it is undermining the typical relationship between the department and the courts.
Professor Bray, you touched on this a little bit in your opening comments. As administrations come and go, the problem of universal injunctions often appear partisan. You've been calling attention to this problem since the Obama administration and have maintained a consistent position across 4 administrations now. From your perspective, is the problem of universal injunctions a partisan one? And then what's the solution?
Thank you, Chairman Grassley. I do not believe it is a partisan problem because it is a problem that has been hamstringing every administration since 2015. The end of the Obama administration, the first Trump administration, the Biden administration, and now the second Trump administration. So if you look at it over time, it's not a partisan problem. At any particular moment, undeniably, it is a partisan problem and has a partisan valence. But legislation should not just be about the moment. Legislation should be about the long view. And I think the only fair way to do this is to knock out the weapon of the universal injunction for everyone. Take it away from Democrats, take it away from Republicans, because what it really strikes at is our ability to have democratic self-government and effective government action by the federal government.
Mr. Panuccio, in your written testimony, you said that it's important to pass legislation to make temporary restraining orders against the government appealable. The legislation I propose does that. Can you expand a bit more on your views here? What are temporary restraining orders, and why is it important that they be that they're appealable?
Thank you, Chairman. It's an important question because the latest trend in non-party relief appears to be courts entering what's called a temporary restraining order instead of a preliminary injunction. Now, in my experience as a litigator and in my years as a lawyer, a TRO was supposed to be a very short-term order from the court when it is impossible for the court to hold a hearing with both parties, and it might enter, for example, a 24-hour TRO until it can get a hearing on a preliminary injunction, an actual hearing with adversaries arguing the facts and the law to the court. But what we're now seeing is the courts are entering these TROs, which can under the rules last for up to 2 weeks and then be extended for another 2 weeks. And the issue is that the courts have interpreted TROs to not be appealable. Now that may be a dubious interpretation, but that is the law of the land right now. And so it is effectively allowing district judges to insulate themselves from review. So it's bad enough that we have district judges saying, I am a ruler for the entire nation. But now they're saying, they're not elected, so the people can't have a say. They're also saying that the appellate judges who are supposed to oversee my decisions, I don't want them hearing it either. So let me enter a TRO instead of a preliminary injunction or some other immediately appealable order. So I do think it is virtue of your bill, Chairman, that TROs or any other similar order would be immediately appealable.
Yeah. Senator Durbin, I've asked Senator Moody to take over for me while I go to another meeting. So
She's very strict. You know.
you proceed. Yeah. Thank you, Senator Moody.
Thank you, Mr. Chairman. So, Professor Bray, I'm going to ask you to stick with me for a second here and talk about possibilities. Along comes President Trump and decides that the following sentence doesn't make sense. 14th Amendment, Section 1. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. So the president decides one of his 103 executive orders will eliminate that language, the language of the Constitution, and question whether or not birthright citizenship is legal in America. Cases were filed. One judge, a Ronald Reagan appointee, said the efforts by the administration are blatantly unconstitutional. If you accept the normal process which you described to us, how should that case be handled if we've done away with the universal application of decisions?
Thank you, Ranking Member Durbin. I think that's an excellent example of how the courts are supposed to work. The courts are going to decide the cases. In every single one, the courts will say there's birthright citizenship under the Constitution. There will not actually even be a disagreement between the circuit courts, and there won't even need to be a decision from the Supreme Court. So what you'll see is distributed decision-making across the federal judiciary that will resolve the question.
But assume the alternative, that there is a federal judge in some state, I'll pick one, Texas or Louisiana, who says, I think the president's right. I believe birthright citizenship is unconstitutional. So you have a case in controversy, and it affects only the cases filed in that district?
Well, it wouldn't affect just the cases filed in the district, because a district court judge actually has no precedential authority, even within a district. There's no ability for a district judge to.
Well, let me amend my comment. Circuit.
Yes, if a district judge took that position, and then it was affirmed by the Court of Appeals, then what you would have is a circuit split between different circuits, and the Supreme Court would resolve that circuit split. And then what the Supreme Court would have is a range of different judges from different geographical places with different ideologies, different generations, all speaking to the same question. And that puts the Supreme Court in a position to do its best work. I don't think that particular legal question needs to be in doubt, but just because one branch goes beyond its constitutional bounds doesn't mean the judiciary should go beyond its.
So I guess my question is, in light of individuals personally affected by this, pregnant women as an example, we just have to let the process play out? Is that what you suggest?
There are ways to get a faster decision, as Professor Vladeck noted, you could have a national class action. But I think the basic commitment, I recognize there can be a human cost there, but the basic commitment of our legal system is you don't get an immediate right decision right away. It takes time. It's like the old carpentry adage, measure twice, cut once. And that's the kind of legal system we have.
Professor Vladeck?
I mean, I think it's worth underscoring the human consequences that my friend just kind of brushed right past. Because if it takes 3 years for that circuit split to get to the Supreme Court, you're going to have 3 years where in large parts of the country, children born to undocumented parents will not be citizens. Some of those children could be subject to removal by the United States on the ground that they are not citizens. It is not possible for the federal courts to order those folks to be brought back. And so that relief that Professor Bray holds out as possible 3 years later is of no help to the children who were citizens under the Constitution, but who were removed in the interim. And so again, I mean, the broader policy question here is what should the rule be in this interim window? Professor Bray and I agree that it's all about what is the status quo while the case gets to the Supreme Court. Should the status quo be the policy is either in effect or not in effect on a nationwide basis, or should the status quo depend upon which jurisdiction you live in and what your particular status is? And that's why it seems to me if we want to talk about real reform, we should be talking about reforms to bolster the other vehicles, the nationwide class action, and not just taking off this stopgap that has emerged in its place.
Thank you.
Thank you, Ranking Member. Senator Blackburn?
Thank you, Madam Chairman, and thank you all for being here. I've got to tell you, being in Tennessee over the weekend and then doing a telephone town hall with several thousand Tennesseans last night, the overreach of the judiciary is something that continued to come up. The way we have seen these activist judges troubles people, and they're wanting to see something done. So they were pleased that we were having this hearing, and they're concerned that you are seeing district judges come in and exercise this sweeping injunctive relief that doesn't apply to the case before them, doesn't apply to the district in which they are seated. So, Professor Bray, I want to talk with you for just a moment. One of the things that Senator Grassley noted and that many of us have discussed is that there is no constitutional and no statutorial authority for federal district judges to issue these injunctions. And so talk for a minute about the effect of that lack of authority.
I'm happy to, Senator. So I think that is correct. There is no statutory basis for granting universal injunctions, and there is no constitutional basis for doing so either. So courts, to be courts, have to exercise the judicial power. And the judicial power is not defined by the Constitution, but the Constitution instead uses what's a known commodity, that is the reference to the judicial power. It is courts deciding cases for the parties. So a universal injunction is fundamentally different from that. A class action is still a case. It's a case, it's a large case, but it's still a case, and if the class wins, the class wins. If the class loses, the class loses, but it's a decision for a case. And what makes the universal injunction different is you have a very small case and a remedy that's for everyone. So my friend Professor Vladeck noted this question about like what's going to be the interim rule? Is the interim rule going to be you have a policy or you don't have a policy? And when we have courts disagreeing about what the interim rule should be, we shouldn't default to as long as there's one court that doesn't like it, it's stopped. That's what makes it a sclerotic effect on government action. The government can't act if all it takes is one court not wanting the rule or the policy to go into effect for the entire country.
Let me ask you also about injunction bonds, because under Rule 65, then a party who is seeking an injunction is required. The bond is mandatory, but we have not seen that used in these nationwide injunctions against President Trump. So speak a little bit about the utilization of injunction bonds and when that's appropriate.
I'm happy to, Senator. I have an above median interest in injunction bonds, and I'm happy to talk about them. So there was an op-ed in the Wall Street Journal a couple days ago that suggested it was a problem for injunctions that were being given against the Trump administration, that no injunction bonds were required. Now, I do think the federal rules of civil procedure require injunction bonds. I think it would be a good practice for federal courts to be requiring injunction bonds, follow the rule, require injunction bonds whenever you give an injunction against the federal government. And I think it's a way of taking into account the regulatory interests of the federal government and the costs injunctions impose. That being said, there's nothing invalid about an injunction just because it's not accompanied by an injunction bond. It still has to be followed. That doesn't mean the court lacks jurisdiction. It's still an order of a court, and it must be followed for that reason.
Thank you. Professor Vladeck, I wanted to talk to you about something you said in your testimony, and I thought it was really very interesting. You said that, and I'm quoting, "We have a Justice Department engaged in highly partisan and ethically dubious behavior," end quote. And I could not disagree with you more in that statement, and I really find it just rich with irony after we've sat here for 4 years and watched President Biden's DOJ weaponized against the American people. We had parents that went to school boards that were called domestic terrorists, and we have seen 2 tiers of justice. So you can submit for me in writing, since my time has expired, your explanation of why the Biden DOJ was not highly partisan, and you have assumed that the Trump DOJ is.
Can I briefly
Thank
respond,
you, Senator
Madam Chairwoman?
You can submit that in writing. Thank you, Senator Blackburn. And we'll turn it over to Senator Padilla.
Thank you, Madam Chair. Professor Vladeck, good to see you. Just wanted to take a moment to follow up on something that you discussed in your opening testimony. Now, there's members of the committee, primarily on the other side of the aisle, that are trying to claim that there's a few radical judicial activists standing in the way of President Trump's agenda. But just as in his first term, it seems that the president's disregard for the law is actually the biggest thing standing in the way of his agenda. So I want to walk through some of the statistics again with you. How many cases have you identified where plaintiffs are seeking an injunction or temporary restraining order against the current administration, where the judge has actually issued a decision, and in how many was the relief granted?
Sure. So, Senator, as of last Friday, and the data obviously has changed since last Friday, the total number of cases we found was 67, and there were 46 of those 67 in which the judge had issued either a temporary restraining order or a preliminary injunction or both.
Okay, that's a lot, and it sounds like a pretty good success rate in terms of the challenges. Now, how many judges have heard these cases, and if you're able to tell or even have a ballpark, these judges were appointed by a president of which party?
Sure. So it's 39 different judges appointed by 5 presidents of both parties, including 2 Republican presidents, President Reagan, President Bush. And the cases are not symmetrically distributed, but the success rate's pretty close. So of those 46 rulings against the Trump administration policies, 9 have come from Republican-appointed judges. And the success rate in those cases has been about 45-50%, so just a little bit lower than what we're seeing in the cases with Democratic-appointed judges.
Okay, that's encouraging to demonstrate that it's not a partisan lens with which these judges are acting now. When it comes to geography, can you speak to where these judges sit? Are they concentrated in one region, one appellate court jurisdiction, one district, or are they spread around the country?
It's been spread much further around the country than what we saw, for example, during the Biden administration. So we've seen 11 different district courts in the 46 cases that have blocked Trump policies, 11 different district courts in 7 different circuits, which is a pretty big shift from as recently as a couple of years ago, when most of the nationwide injunctions against Biden policies were coming from district courts in Texas, Louisiana, and Missouri.
So thank you, and appreciate your verification of some of the data that I have in front of me. To me, it confirms not just the numbers, but that it's not the judges getting in the way of the Trump agenda. It's certainly not a few radical judicial activists either. Now, question on a different topic for you. You're an expert on sensible ways to reform the judiciary to make it better work for the American people in a way that was intended by the framers of our Constitution. In your view, what are the most pressing reform needs when it comes to the federal courts?
Yeah, I mean, I think the most pressing needs, I think, are to avoid the more general ability of parties to manipulate the federal courts. In ways that we've seen, to some degree in administrations of both parties, but for various structural reasons, I think even more so during the last two Democratic administrations. Just to take one example, I mean, my friend Professor Bray, I think, joins me in criticizing so-called single judge divisions and judge shopping. That was a phenomenon we saw over and over again during the Biden administration. The only really sort of obvious target for that kind of behavior during the Trump administration, the district court in Massachusetts, changed its rules actually to prevent that kind of behavior. And it seems like that can be a model, Senator, for a nationwide rule that this body could impose to avoid the appearance that litigants are steering cases to a particular judge because of that judge's ideological commitments.
Yeah. No, and that's critical for the functioning of the judiciary and people's confidence in the process. Last question, in my time remaining, is sadly very timely. Because the attacks on the judiciary isn't limited to attacks on judges by the Trump administration. Now we're seeing attacks on the legal community and specific firms or lawyers that represent clients and causes at odds with the president's ambition. Can you speak to the chilling effect that these targeted executive orders are having on the legal community and their ability and willingness to take on clients or employees that might dare to disagree with President Trump?
Yeah, I mean, I think we're seeing a chilling effect, Senator, in some of the law firms that are, making these agreements with the president to not represent particular clients, to devote hundreds of millions of dollars to pro bono litigation in support of the president's agenda. That kind of distortion is a problem not because of Democrats versus Republicans. That kind of distortion is a problem because, as the Supreme Court itself explained in 2001, meaningful access to lawyers is actually central to the ability of the courts to play their essential role in our constitutional system.
Thank you, Mr. Vladeck. We appreciate your testimony. Thank you, Senator Padilla.
Thank you. Just following up on that, I mean, is there agreement among the three of you that dealing with forum shopping would be beneficial for the judiciary and for the strength of the rule of law? Do all of you agree on that?
Yes, but it would only solve part of the problem.
Oh, I understand that, but it would be worthwhile. Professor Vladeck, you said that. How about you, Mr.?
Plaintiffs, if they have the ability to file a lawsuit if they're appropriately negotiated. Excuse me. I think plaintiffs, if they have the ability to file a lawsuit in a district, should be able to do that. I think the incentive for forum shopping is that you think you can get a judge who can be a ruler for the whole nation. So fix the problem of judges overreaching their power, and you'll.
So you're okay with forum shopping, just so I understand.
Well, it depends what you mean by that, Senator.
I mean,
if you mean plaintiffs choosing
where you file, and what lawyer wouldn't do that? Where you think you can win?
Well, there's all kinds of reasons why lawyers choose to file in different districts. It could be because
okay, I think I got your answer.
But judges
two against to reform that, and one thinks it's fine. The next thing, just this practical question of a class action lawsuit versus an individual suing. I mean, I'll ask you, Professor Bray, because you're talking about class actions, and I support class actions. There's been a lot of debate within the committee about whether they're useful or not, and a lot of pushback on the use of class actions. But there's an enormously increased burden on the plaintiffs in order to get class certification, is there not?
Senator, with respect, this bill, the chairman's bill, would leave class.
I'm not asking about the chairman's bill. I'm just talking, I'm a lawyer. Somebody comes in. Birthright citizen is the claim. I'm a small town lawyer. That's what I was, White River Junction. I say, you know what, you're right. Let's take the case. I'll do it. But if I have to go get a class certified, just tell me the steps I have to go through for getting that class certification, as opposed to just taking my client who came into my White River Junction office and we go to the federal district court in Burlington.
So class certification does require more steps, but it's entirely appropriate given that what you're seeking is a remedy to represent everyone.
No, I'm talking, I understand that it's appropriate. I'm just talking about what is the practical burden in terms of cost, in terms of what kind of legal power you have to have, as opposed to a single lawyer who has a single client who comes in to see me and wants relief. What's it going to cost for me to do a certification for class, as opposed to me just filing and paying the filing fee at the federal district court?
So I do agree, Senator, that there are more requirements, and that means more attorney hours and more costs.
Right.
So I agree with that. But it is also matches the scope of the relief sought. And
All
so
right.
it really is a matter of
I get that, but there's an acknowledgement here that it's a much bigger deal. You know, one of the wonderful things about our justice system is that an individual who is harmed can come into a lawyer, and that lawyer may take it pro bono. But if you have to have the resources of a major firm, it's a much bigger uphill challenge to get your day in court. Second thing, you know, we've got a situation here with the courts that's unprecedented, and we've got a real debate on both sides of the aisle about who is weaponizing the court. I understand that. But do you, Professor Vladeck, have a view about whether the and by the way, let me just give a context. The context that we're in right now is the separation of powers in three co-equal branches of government. And my view is that the legislature is essentially ceding authority to the executive, and that that's very dangerous in the long run for the well-being of our democracy. That's my point of view. I'm not asking you whether you agree or don't. But I'll ask you, Professor Bray, what do you see as the impact on the rule of law when the executive orders the Justice Department to dismiss a corruption case against the mayor of New York City in order to get his cooperation on a executive policy on immigration?
The rule of law applies to all three branches, and each one needs to act consistently with the law. That includes the executive, and also, for the subject of the hearing today, that includes the courts. I am with you in thinking that it is an imperative for every branch.
I know that, but I'm talking something that real world. This happened. We got a major corruption case against the mayor of New York City, and it was dismissed for political reasons. Does that conform to your view of how the rule of law should operate?
No, it does not.
Thank you very much.
Thank you, Senator Welch.
Thank you, Madam Chair.
You know, I was struck by the questions on the law firms and the approach of President Trump to try and bring them back to the table of working with this administration. I was struck, I found some of that ironic, and the questioning, Mr. Panuccio, and welcome, great Floridian from the great free state of Florida, considering the way the law firms approached any conservative lawyer that was coming out of the last administration and the treatment of such. I thought it was very ironic. Did you notice that many lawyers who had stood up for good policies were refused employment or shut out of some of these large law firms?
Well, thank you, Senator. You know, I'll be circumspect in my answer here just because I'm here to testify on universal injunctions. However, you know, I think it's an open secret in Washington that if you work for a Republican administration, you face a much harder job market coming out than if you work for a Democratic administration. I don't think anyone doubts that to be the case generally over the years, not just specific to the Trump administration, but going back to the Bush administration and others. And you often now hear people say, well, if you take that job, you may never work again. I think that happens much more often with Republicans than Democrats, and it reflects that, you know, law firms, like many institutions in this country, are overwhelmingly weighted in one direction politically than the other.
Mr. Panuccio, you have long been an academic, so to speak, on many of these challenges we see with nationwide injunctions. And I appreciated your testimony, specifically when you quoted Justice Kagan, appointed by a Democratic president, when she said, "It just can't be right that one district judge can stop a nationwide policy in its tracks and leave it stopped for the years that it takes to go through the normal process." And what struck me by that is this term normal process by someone who would know how long it takes to go through the normal process. And that basically means, it could mean the 4 years that an entire term that a president is in office. Isn't that right?
A full appellate process to the Supreme Court could take several years, yes. But, Senator, I would say, to coin a phrase, this is what democracy looks like. The founders at the Philadelphia Convention considered turning the judiciary into what was called a council of revision, which would mean the judiciary had a chance to review laws and policies of the legislative or executive branch before they went into effect. And the founders decided against that. And they said the judicial power is cases and controversies among the parties. The whole point of democracy,
Let me just stop you right there. I want to focus on the normal process, the years it would take to go through the normal process, meaning let's take for a moment that we can rightfully change the law to make sure that the decisions apply to the parties before the court only. For the administration of justice to have any effect, and the people to believe that chaos and controversy and conflict can get rightfully addressed expeditiously, should it take years for these cases to go through the courts, or should Congress consider an expedited process for matters of great national concern?
I think it would be appropriate, Senator, for if the Attorney General were to certify a case as of great national importance, for there to be a faster process or mandatory jurisdiction of the Supreme Court. I will say this, though. For individual parties, if an individual party is aggrieved by executive action or legislative action, the individual party can go to a district court and get an injunction that gives complete relief to that party. And that doesn't take years. That can take days. Can take hours in certain cases. That's why the district courts are there. They're there to grant relief. Now, if what you're seeking is a change in policy nationwide, that is governing. That is what the elected branches do. But for individual parties, I don't think it's years for relief, as we've seen.
And Professor Bray, thank you for joining us. As a former judge myself, as someone who has great reverence for an independent and fair judiciary, it concerns me that the public in general, based on what we're seeing in the numbers, and I thought it was really interesting when we say 46 injunctions or orders that have gone against this administration, 9 were by Republican judges. Do you believe that limiting the relief sought to the parties in front of the court will help alleviate this idea that these are judges acting in a partisan nature?
Thank you, Senator. I do think it will reduce the appearance of partisanship because you get decision-making by more judges across the country instead of one judge giving an injunction to decide the question for the whole country.
So you believe the proposed legislation from Chairman Grassley would address bipartisan concerns?
Absolutely.
Senator Hirono?
Thank you, Madam Chair. This is a question for Professor Vladeck. Professor Bray noted in his testimony the concern about extreme foreign shopping, especially in single judge districts. So I think you're familiar with a bill that I had introduced, which I intend to introduce once again, about the Stop Judge Shopping Act. It was not motivated by a concern about nationwide injunctions, but here we are. I think it has relevance. And I'm wondering, Professor, do you think that parties would seek and receive fewer nationwide injunctions if they were not able to judge or foreign shop for favorable outcomes? That's happened in the Texas mifepristone case.
I think there's no question, Senator. I mean, I think the data, such as it is, shows that there was a higher success rate when parties sought nationwide relief during the Biden administration in single judge divisions than when they filed in courts that had random assignment to more than 3 judges. And so, that's a small data set, and I don't want to overstate it. But yes, there's almost no conceivable way in which it wouldn't be smaller.
So that would be, in my view, it would be a fair, I suppose, way of addressing the concern over nationwide injunctions.
So, I would say, if I might, 2 things. The first is that I think distributing assignments would at least mitigate the allure of nationwide injunctions in cases in which the median judge might not issue it. Professor Bray referred before in the birthright citizenship case to his confidence that any judge would block this order. The issue is not those cases. The issue is cases where the identity of the judge might be dispositive. So that's piece one.
Especially in single judge districts. This is again for you and perhaps Professor Bray. I'm trying to understand the practical effect of Chair Grassley's proposed legislation wherein where you limit the relief that a court can grant to only the parties before the court. So I would like to know how, in a case like the Mifid-Bristol decision, how the relief granted would apply only to the parties before the court.
So, I think it's even more powerfully illustrated, Senator, in the birthright citizenship cases, because in a context in which you had, say, individual non-citizen parents, or even, a group of non-citizen plaintiffs, say, in Northern California, seeking to block the birthright citizenship policy, an injunction that only ran to them would be of no benefit to non-citizen parents in Southern California, in Oregon, or anywhere else in the country. And so you would need litigation, on a retail nationwide basis to ensure that that these parents could have confidence that when their children are born in the United States, they're born citizens.
So you're saying that multiple lawsuits must be filed to obtain the relief if we're going to go with what is in Senator Grassley's bill, that the relief will only be granted to the parties before it. There are certain issues that certain cases where it wouldn't make sense.
Well, and so Senator, unless, and this goes back to the chairman's opening statement, unless you were in the same bill to reinvigorate nationwide class actions, unless you were to effectively trade nationwide injunctions for a reinvigorated nationwide class action where you'd be able to show that all non-citizen parents who have a childbearing age, right, are affected by this order.
Professor Bray, do you want to
I would love
weigh
to.
in?
Yes, I would love to. Thank you, Senator. So I think the Mifid-Bristol case is a great example. You couldn't really have an injunction to protect the plaintiff's interests there because the plaintiffs didn't have standing. But what the case shows is...
Well, let's say that the plaintiffs did have standing.
What the case shows is the lack of fit in so many of these cases with universal injunctions between tenuous, narrow standing claims, including DAPA, the original 2015 one, the tenuous, narrow standing claims, and massive universal relief.
Okay,
and that's not the way
I'm saying that let's say that the standing issue was overcome, and then you have a court that says what the FDA did not comport with the APA, and can that court limit that holding just to the plaintiffs before him or her?
Well, in that sort of case, the court should adjust its remedy to whatever the injury is. So you'd have to have a real specific injury to then tailor the injunction to it. And in a case where you don't have one, you can't really have an injunction tailored to the remedy. Tailored to the injury. So we'd have to hypothesize an injury and then hypothesize an injunction that matched it.
Thank you, Professor
I realize my
Bray.
time is up, but my point is that I think there are some concerns about the approach that the chairman is taking in his bill.
Thank you, Senator Hirono. Senator Hawley.
Thank you very much, Madam Chair. Thanks to all of the witnesses for being here. Let's just start by talking about the need to be here today and the fact that what we are seeing happen in district courts is, historically speaking, really unprecedented until recent years and completely out of sync with our constitutional system. You alluded to this, Mr. Panuccio, the way that our founders designed our constitutional system. Mr. Bray, Professor Bray, let me just start with you. According to your scholarship, when's the first time that a district court issued a universal non-party injunction of the kind that we're talking about today?
I think the first one is 1963. There is historical debate about when they started in the 20th century, but I think that would be the first one. But they certainly are not traditional in equity before then, and they were a peripheral backwater until 2015.
So 1963, so the Republic is 200 years old almost by the time we get the first district court issuing a universal injunction binding parties who are not before it. And even then, as you just alluded to, then there's this period of quiet where they're really not issued until the 21st century, until the 2010s. Is that correct?
That's correct.
And then we see this explosion, as you can see in the chart behind me. In the Bush years, Bush 43, we have 6 universal injunctions binding non-parties. In the Obama years, we have 12. You referenced one of those cases, Professor Bray, in your opening statement, your written statement. And then under Trump in his first administration, 64 universal injunctions binding non-parties, 14 under Biden, and now 15 under the second Trump administration in 1 month alone. Mr. Panuccio, let me just come to you. Tell us why this pattern that we're seeing here, and there's a clear partisan valence to it, but there's even more of a recency valence. I mean, this is something that just did not happen until very, very recently. Why is this so distortive to our federal system?
Well, thank you, Senator. It's distortive because it has judges operating outside their constitutional role. They are exerting policy-making power over the whole country. And the issue is this. We are a republic. Those who get to exercise policy-making power, like yourself, like this body, have to face the electorate every 6 years, 2 years, 4 years, whatever it is. Judges do not. We gave them life tenure so that they could be insulated and make decisions without fear or favor. But we limited the judicial power to cases and controversies, just the party before them. And in my written testimony, I note that Hamilton said it's the least dangerous branch, but he had a caveat. Only if they exercise the judicial power. If they range beyond it, then it can be the most dangerous branch. And the public's confidence will be undermined because they have no chance to get rid of these judges because they have life tenure. They don't want to be ruled by kings. They want to be ruled in a republic where they have a vote.
And here's my concern is that this pattern of, I think, abuse, this pattern of out-of-control behavior that we're seeing that's illustrated on the graph that's behind me is not decelerating, it's accelerating. And now we're seeing it not just with injunctive relief, we're seeing it in other orders, other procedural forms that are deliberately designed to insulate the judges, the district courts from appellate review. Temporary restraining orders. You mentioned this, Mr. Panuccio. All of a sudden, we've seen a huge uptick in just the last few weeks in district courts issuing what looks a heck of a lot like a nationwide non-party injunction, but it's styled as a temporary restraining order. Now, Mr. Panuccio, if I were a judge who wanted to insulate myself from review, why might I choose the temporary restraining order vehicle to do it? Why is this happening?
Because, Senator, under current precedent, TROs, temporary restraining orders, are not immediately reviewable, unlike a preliminary injunction. So if you are a judge who believes a policy is unlawful and you want to exert power nationwide and you don't want anyone to review, the voters certainly won't. The only people who can do it are appellate judges. So you issue a TRO, then you extend it for another 2 weeks, and for at least a month, you can't be touched by the appellate courts.
And has this happened in the last few weeks?
It has been happening. We've seen straying beyond the typical preliminary injunction to TROs and other what are being called administrative stays, which also appear to be unreviewable.
So here, I think, is the issue that's before us. In one sense, it's entirely appropriate that we're here today, and it's entirely predictable given the urgency of this situation. In another sense, it's sort of a wonder we need to have a hearing on this at all, because my Democrat colleagues for the last few years have been decrying the very behavior that we're talking about now. And I think, as you pointed out, Mr. Panuccio, we've had multiple members of the last administration, for example, Joe Biden's Solicitor General Elizabeth Prelogar, she herself said in court, by the way, this wasn't a stray comment to the press, this is her at the Supreme Court, a court of equity may grant relief only to the parties before it. District courts violate this principle by issuing universal injunctions. Elena Kagan, Justice Kagan, it can't be right that one district court judge stop a nationwide policy in its tracks and leave it stopped for years while it goes through what is otherwise the normal process. I would just say to my Democrat colleagues, it shouldn't be, to quote the chairman, that one thing, or to quote the ranking member, that it's one rule for Democrats, it's one rule for Republicans. Let's make it one rule across the board that no matter who appoints you, a judge can only bind parties who are before her or him. There are no nationwide non-party injunctions Let's make that the standard, and let's return these courts to the proper functioning of our constitutional system.
Thank you,
Madam
Senator
Chair.
Hawley.
I almost.
You stuck to that timer. I am so
For
proud
me,
of you.
it was really good.
Senator Schiff.
Thank you. I want to take a moment to acknowledge what took place today in the Southern District of New York when the Justice Department dismissed a corruption case against the mayor of New York City, not because of a lack of evidence, not because of any misconduct by the prosecutors in the case, but because of the most serious misconduct of the Attorney General and the top leadership of the Justice Department. Because the Justice Department wanted to leverage that case against the mayor by dismissing the case without prejudice so that they could use him as a political pawn to help effectuate their immigration policy. That just happened today. It is one of any number of serious abuses of the rule of law by this Justice Department. And instead of having a single hearing on what the department is doing, or a single hearing on all the other plainly unlawful acts of this administration, no, instead of having a hearing on any of those things, Republicans are having a hearing on the one tool that can be used to try to mitigate the harm of these illegal actions. Now, I completely concur that whether nationwide injunctions are a good thing or a bad thing has depended entirely on who they're being used against. I count no less than 26 of my Republican colleagues who were vigorously supportive of a nationwide injunction against the use of mifepristone. No problem supporting a nationwide injunction in that case. And of course, on the Democratic side of the aisle, we are applauding injunctions against the unlawful actions of this administration. Where I think I come down at this moment in time gets to your point, Professor Vladeck, and that is the use of nationwide injunctions against an administration that has proven so breathtaking in its lawlessness and who has engaged in such a surge of illegal actions, the effort to do away with this singularly vital tool, I think you called it, at this time would be disastrous for the country. It doesn't mean there is not going to come a time when we should agree on a bipartisan basis to place limits on this capability. I think we should, in particular on the abuse of forum shopping, on picking judges solely on the basis of their political predilection or who appointed them for the purpose of a nationwide injunction. But this is not the moment to do it. This is the moment, frankly, we should be focusing on the illegality, not on the tool to constrain it. That doesn't mean we're powerless to work on legislation on this, and I think many of us have concurred with the idea of legislation that takes effect after this term, when we don't know who the next president is. Senator Cruz, you and I went to the same law school. There was a wonderful professor at the college named John Rawls who wrote a book you probably read about the veil of ignorance, where you cast a veil of ignorance over society and society would develop rules to govern that society, not knowing their attributes, their race, their religion, their gender, none of that. Well, far be it for me to advocate a further veil of ignorance over this body. We are ignorant enough. But perhaps the ignorance of not knowing who the next president is useful here. We should come up with a sensible reform of injunctions and forum shopping, but there's no way this is going to have bipartisan support unless we defer its application until after this administration, when we don't know which way it will cut. I think the same is probably true about filling judicial vacancies. We have just come to this broken place where probably the only way to get things done of this significance is to postpone their application until we don't know who the president will be. My time is almost up, but Professor Vladeck, in the moments I have left, I would yield to you for any kind of response.
Well, just that, I mean, Senator, I think it's revealing that, I, as the minority witness today, am not here defending in all contexts universal injunctions. I've written before that I think that there are too many of them, I've written before that they raised at least some of the prudential concerns that Professor Bray has raised. And I just want to endorse your suggestion that holistic reform to make litigation against the government less manipulable is something we should all be able to support, but that holistic reform has to be about more than just closing off this one avenue today, when there have been other developments that have closed off the other avenues historically that have made Senator Hawley's examples become so much more relevant today.
Thank you, Mr. Vladeck. Senator Schmidt.
Thank you, Madam Chair. It occurs to me that, and I don't want to retread some of the same tire tracks here, but broadly speaking, really what we're talking about is a separation of powers issue. I mean, this is ultimately, when you distill it, this is one way it plays out. As one of the witnesses had remarked, the founders never envisioned this sort of scenario. They certainly never envisioned the scenario. And the abuse that we're seeing here recently sort of puts an exclamation point on it. But I want to use one example of, and it's not a nationwide injunction, but just take Judge Boasberg's ruling here in our nation's capital. When I think the Supreme Court was very clear in Justice Jackson's famous concurrence in Youngstown Steel that the high watermark of presidential power is when you have congressional authorization, when you're actually performing Article II duties as Commander-in-Chief. And the Alien Enemies Act clearly grants that. It's silent. The text of the statute's silent on judicial review, and of course this is pre-Marbury, so they certainly would have never intended that anyway. Yet we've got a judge, and there's other issues at play. Habeas, you've got due process that's sort of at play, but you have a judge that feels compelled to make this sort of decision, and inherently it's Article II power and or a political question that's not justiciable. I mean, you could go through a number of different questions. Could the court, a few of them here, could a judge have stopped Andrew Jackson from firing on the British at the Battle of New Orleans because we'd already signed the treaty again? Of course, the answer to that is no. Could a judge stop FDR from responding to the Japanese bombing of Pearl Harbor because they hadn't formally declared war until 2 hours later? These are questions, these are core Article II powers. So when we talk about the separation of powers, I think we don't teach civics anymore, but if we did, you would learn that the Article III branch, its power is not unlimited either. It's in fact limited. And Congress gets to limit Article III power, which is sort of, I think, one of the reasons we're here today. And I think we've seen, Senator Hawley had the graph of when we've seen this acceleration. And I think the chairman's bill, I'm a co-sponsor of it, I think the time is now. And maybe there is this sort of mutually assured destruction that Senator Schiff is talking about. Maybe these are the conditions by which you actually can get something like this done. But I do want to raise one other question. And Mr. Panuccio, I offer this to you. I mean, it's an open secret. The appellate bar and the politically sensitive litigators know that this randomly assigning district court judge thinks something's wrong here. Something's happening. It is statistically impossible for Judge Boasberg to get the cases he's getting. It's statistically impossible. When I was Attorney General in Missouri, we saw this in the Eighth Circuit. The one Democrat-appointed judge ended up on the panels. It's statistically impossible for that to have happened in that period of time. So I wanted to ask you, what are some reforms that we might consider to ensure that this is truly random? Because if one of the remedies is that you actually have a randomly selected district court judge, then they ought to be a randomly selected district court judge. Do we have like a lottery? Do we have a big wheel? What are some ideas? Because I think there's enough suspicion right now that it's affecting the credibility of the court.
Thank you, Senator. I'm not an expert on the wheels across the country. My general understanding as a litigator is that most courts employ a wheel. How that wheel is weighted can change from district to district depending on the judges. So, for example, in one of my home courts, the Northern District of Florida, there is a public order that tells you exactly how the wheel will work. 35% of the civil cases to this judge, 60% to this judge, 5% to that judge. My own view is that the more transparency courts have, the better, so that at least the public can know this is how the wheel is working. Even if you don't see the wheel operate, you at least know this is the weighting of the wheel, and that can be based on how many active judges you have, how many senior judges you have, how many judges you have in the district, and the geography of the district.
Well, I would just suggest that I think that in addition to what we're talking about here today, there probably ought to be more reforms contemplated, because this, I think, you don't need to be some soothsayer or the oracle at Delphi to understand that there's something amiss here. Thank you.
Thank you, Senator Schmidt. Senator Whitehouse.
Thanks very much. Thanks you all for being here. The first thing I'd like to do is put into the record a partial list that my office pulled together of nationwide injunctions against the Biden administration that my Republican colleagues celebrated and rejoiced in. So this is a bit of a what side are you on, who's in power right now type of debate we're having. The second thing that I'd like to do is to point out that the discomfort to fury, that's kind of the general range, about decisions against the Trump administration may actually have a lot to do with the unprecedented lawlessness and law-breaking of the Trump administration rather than a weird cabal of judges trying to intrude. And it rolls into something that's very important to the court right now, which is threats to judges and to their families, which I think there's significant evidence to show has been orchestrated and is systematized. It obviously starts at the top with people like Trump and Musk making threats about impeachment and whipping up. In the case of Musk, he has curated a whole armada of characters, to put it nicely, on X, who, when he targets an individual, barrage that individual with abuse and threats. The idea that Musk does not know that he has this curated armada of, let's just say, not entirely all there individuals who are willing to go and harass and threaten when he's identified a target seems unlikely, seems like he knows, seems like it's deliberate. And in that regard, I'd like to put into the record a letter that I wrote to Judge Bredar, who is the new head of the Judicial Security and Independence Task Force. For the first time, the judiciary's felt it has to put together a task force to deal with the campaign of threats that begins at the top with Trump and Musk and then works its way down to where individual judges are not only critiqued, that's fair game, but they're threatened. They're threatened with impeachment to the point where the Chief Justice has had to stand up and say, no, no, no. If you disagree with the decision, that's an appealable issue, not an impeachable issue. So I ask that both be put into the record, both my letter regarding what they have to do. Here's my concern.
Without objection.
I don't know that the Marshal Service is actually going to provide the protection that the judges need. We had a very good response to the Rhode Island judge who was subject to these threats. The court is very impressed and pleased with what the Marshal Service did in that instance. But it gets a little bit different when you start going after, it seems always to be female family members. When you start going after spouses, wives and daughters and things like that, you know, if you go after a judge's daughter who lives in a different location, how does the Marshal Service respond to safety issues related to the daughter who lives in a different city, who's not even in the district for the marshals. What do you do about that? And do the marshals have any authority to do any investigative work to see what can be done to understand the threat posture that these judges are facing and who's behind it, and when is it deliberate, or are they constrained only to provide protection but not look into what the threat is? I think those are really important questions, and I hope that this judicial group will take a good hard look at that, and that's what my letter requests. The last thing I'd suggest is this ain't that easy. If you are a district judge and you decide that a rule is unconstitutional or an action is unconstitutional, and that action plays out across multiple states, that, as the law of that case and as the law on that subject, ought to be applicable in other districts. And the idea that every time some action is deemed unconstitutional, you've got to file it 93 times to hit every single district before it can apply. I mean, I think we get into some very significant practicality issues as we mount this little crusade that runs exactly counter to where my Republican colleagues were when the shoe was on the other foot.
Thank you, Senator Whitehouse. Senator Cruz.
It's long been said that hypocrisy is the tribute that vice pays to virtue. I have to admit, I'm enjoying listening to my Democrat colleagues suddenly discover the virtues of the rule of law after 4 years where they brazenly supported the most lawless Department of Justice and the most politically weaponized Department of Justice our nation has ever seen. We just heard the senator from Rhode Island talk about the imperative of protecting judges. And yet not a single Democrat senator cared about the violent protesters that showed up outside Supreme Court justices' homes, including, I might note, female justices like Justice Amy Coney Barrett, threatening their family, and Joe Biden's attorney general didn't do a damn thing and refused to enforce the law to protect those judges. Why? Because he agreed with the violent protesters and he wanted to intimidate and threaten those judges. Professor Bray, under our Constitution, who should decide elections, the voters or unelected judges?
The voters are the ones who should vote in the election according to the laws, and the laws sometimes have to be applied by the judges if there are cases.
And under our Constitution, who is charged with making policy decisions? Elected representatives elected by the people or unelected federal judges?
I think the question of policy, Senator, is a little broader than the particular case. So the laws should be enacted by Congress. That's where the fountain of law.
Policy decisions are the elected branches.
Right.
Law is the province of the court. Policy is the province of the elected branches. These are not complicated. Professor Bray, let me ask you this. Do the federal courts have power to issue remedies for people who are not parties to a case?
That's a question I agree is not complicated. They do not have that power.
Is the phrase nationwide injunction or universal injunction found anywhere in the Constitution?
It is not.
First chart. In the first 150 years of our republic, how many nationwide injunctions were issued?
My view is that there were not any until 1963.
0. Now fast forward. How many nationwide injunctions were issued in the entire 20th century?
It's a small number. I would think it would be a dozen, give or take. It's not large.
27, actually. Excluding Trump's first term, how many nationwide injunctions were issued in the last 20 years?
Far more than that.
32. From 2001 to 2024 against Biden, Obama, and Bush, 32. And how many nationwide injunctions have been issued in the last 2 months alone?
There have been quite a few.
37. Let that sink in. There have been more nationwide injunctions in the past 2 months against President Trump than in the entire 20th century. There have been more nationwide injunctions against President Trump in the last 2 months than both terms of George W. Bush, both terms of Barack Obama, and Joe Biden's term. We saw during the Biden presidency lawfare, indicting President Trump 4 times, using the machinery of justice to attack him, and that was an attack on democracy, because Democrats today hate democracy. Democrats today are angry at the voters for re-electing Donald Trump and electing a Republican Senate and a Republican House, and they engaged in lawfare to stop democracy from operating. Understand, this is the second phase of lawfare. Second chart. This is the second phase of lawfare. Now that their efforts to indict President Trump and stop the voters from re-electing him have failed, they're going and seeking out individual radical judges to try to shut down policies, and they are forum shopping like crazy. Give me any loon judge put on the bench by Obama or Biden who disagrees with a policy. We just saw a judge flagrantly ignore U.S. immigration law concerning TPS being revoked. U.S. law explicitly said there's no judicial review for that, but hey, they found a judge who says, you know what? We, the Democrat Party, we are the party of illegal aliens. We are the party of murderers and rapists and gang members, and the Democrat Party exists here to fight to keep murderers and rapists and gang members in your communities. There's a reason the Democrat Party is at 26% approval nationwide, because they put radical policies ahead of rule of law. Nationwide injunctions are an abuse of power. It is the judiciary acting as policy deciders, and it is incumbent on this committee and this body to rein in the abuse of power from these unelected radical judges who are trying to overturn the election because they disagree with what the voters decided.
Thank you, Senator Cruz. Senator Klobuchar.
Okay, that was a lot. Let me start with a few things. Number one, we love the democracy, and I believe what we should be having is a civil debate about how we can best, if Donald Trump wants to make changes to the government, we should be doing it in a legal way, not how he's doing it. And the only reason there's all these injunctions, Senator Cruz, is because he's violating the Constitution. Why would Trump-appointed judges...
Why don't you file them in red districts?
Senator Cruz.
Why... What did you just say?
Why don't you file them in red districts? Why are the Democrat attorneys general seeking out left-wing, blue
Be patient with Senator Cruz's activity in this building.
Senator Whitehouse.
He's entitled to...
I'm just going to ask for a point of order. Madam Klobuchar, Senator Klobuchar.
Senator Moody, we have debates on this committee. They occur regularly.
Let's let her have her time, and then we'll get back to that. If you want to wait, we'll get back to you, Senator Cruz.
She's welcome to
Senator
answer the
Klobuchar,
question or
go
not.
ahead.
It's her choice.
Go ahead.
I'm so
and I would
excited
encourage
to
you
be
to answer.
following Senator Cruz once again.
Excuse me?
But I will say
Excuse me? I didn't hear you. What did you say?
To be following him. He and I have a long
I was permitting you your time to continue. To be following him in order. Excuse me. Go ahead, Senator Klobuchar.
During hearing.
Go ahead, Senator
That's what I'm
Klobuchar.
referring to.
Go ahead.
And I will take more than my time, since he's taken more than his time to yell at me.
Go ahead.
So what I
I'll
will
mark the
say
time.
is that
I'm not yelling. I asked a question.
Senator Cruz, please. I'll give you time. Senator Klobuchar, I've got the time, and you'll be allotted
I
time.
am making the strong case that the reason all these cases have been filed, and the reason that these judges who have been appointed by Ronald Reagan, yes, they still exist, and the Bushes and Donald Trump, judges appointed by Donald Trump, have been making these decisions is because this is not legal. Donald Trump himself has used his social media account, the White House account, to post an image of himself wearing a crown saying, "Long live the king." The issue is that we do not live in a kingdom, and Elon Musk is not his court jester. Ours is a nation of laws in which no one is above the law. That is why 39 different judges from vastly different backgrounds, appointed by 5 different presidents, have made clear that these are illegal actions. And these judges have rightly blocked these actions. And it is important that we not lose sight of the underlying cause of these injunctions. It is not that these judges are crooked or lunatics or evil. Those are words used by the president and his allies. It is because the administration is violating the Constitution. What happens when they use these kinds of words? You see more and more threats against judges. And that is what we're seeing. That is why federal judges and the U.S. Marshals, who are responsible for protecting them, are sounding the alarm about a spike in threats against judges. This is serious. And unlike what Senator Cruz said, I'm remembering when the threat was made, the horrific threats, and the man was in Justice Kavanaugh's, on his neighborhood, on his street. On a bipartisan basis, we came together and got more funding for the judges and changed things so that they had more protection. So what he said was completely untrue in terms of Democrats and Republicans decrying violence. We didn't just decry the violence, we actually did something about it in response to a court that is run by Justice Roberts, who is a Republican appointee. So I think that kind of language actually makes the situation worse when it's not even true. But unfortunately, Senator Cruz left, so he did not hear my response to what was a lie. President Trump's attacks on these judges has made for some major risks for these judges. I would ask you, Mr. Panuccio, and not in a partisan way, just normal, as a partner in a law firm, have you ever taken to social media to personally attack a judge who ruled against you? Senator. That's all my question is.
Senator, thanks for the question. I think that attacking judges personally and not their reasoning, well, let me just give you a quote. I want to tell you, Gorsuch, I want to tell you, Kavanaugh, you have released the whirlwind and you will pay the price.
I've asked
you. You want to know, you won't know what hit you if you go forward with those awful decisions. That was something that Senator Schumer said, and I thought it was awful, and it unleashed a wave of violent threats against Supreme Court justices. I do think that's problematic, that kind of language.
I have no doubt the language is a problem on the left or right. I was just asking you if you have ever personally attacked a judge after you disagreed with the ruling. I'm asking you.
I have not.
You did it. Thank you. And you believe that the proper recourse is to appeal when you disagree with the ruling?
When I disagree with a ruling on behalf of a client, I appeal.
Thank you. That was all I wanted. I was not going to criticize you. I believed that you would not have done this. And so that is my point. When people do this, and right now we have not just a random person on social media doing it, we have the President of the United States doing it. And I would just ask you, Professor Vladeck, in your opinion, are the judges who ruled against the president radical and rogue judges?
No. And just if I might, even though he has also left the room, Senator Schmidt suggested it was statistically impossible that Chief Judge Boasberg has been assigned to multiple cases in the D.C. District Court. I think that rhetoric is highly inflammatory, in addition to being just mathematically incorrect. There are 31 different cases in the D.C. District Court alone in which D.C. district judges have ruled against the administration. There are 11 or 12 active district judges. The notion that one of those judges would have multiple of those cases is not statistically impossible. It's statistically certain.
And if the president does not want to have judge rule against him, isn't the answer that he just follows the law?
One would think, but I think we live in a bit of an upside-down world at the moment.
Okay, so this hearing was titled in a very academic fashion, Universal Injunctions. And we can make it all academic if we want. Clearly we haven't with Senator Cruz's remarks. But I just want to make the point that this has a real consequence, that these cases that are coming before these judges. This is outside of their decision, which is based on the law and the facts. Sometimes they've ruled with the president, sometimes they've ruled against the president. But just to get it so people understand this isn't just some academic exercise about injunctions and if they're a good thing to have legally. Last month, a federal judge blocked the administration's plan to slash NIH funding for medical research. Could you talk about the impact if the judge had not been able to issue a nationwide injunction?
Sure. So Senator, briefly, because I know our time is limited, NIH hands out thousands and thousands and thousands of grants. If you required the recipients of each grant to litigate the rescission of each of those grants on a retail basis, you would have gaps in cancer research. You'd have gaps in all kinds of, work by the National Institutes of Health, because it's not possible that those thousands of the mass action by the government could be challenged on a retail basis in federal courts.
Thank you so much. And
could I get a second round
Senator
of questions?
I allowed you to go way over your time in order to make up, and I wrote it down.
Round?
No, ma'am. I just wanted to let you know that I did give you extra time and over what was taken up.
The
So thank you
practice of
so
the-
much. I appreciate it.
Okay, a lot of times when senators are still here and there is no one else here, they let them have a second round?
Absolutely. I'd just like one moment to ask about an issue that
Okay,
came
well, you
up
should, yes.
that is regarding TROs. And I just want to make sure that the committee as a whole has an understanding of TROs, how they are used, so that they can take this into account in the proposed legislation. TROs have been used historically by judges, and they haven't been immediately appealable. And it is in the proposed legislation that we change that practice through law and make sure that TROs are appealable. Do you think that would remedy some of what is happening today and some of the distrust that certain judges are making partisan rulings? Mr. Panuccio.
Thank you, Senator Moody. I do think that when a TRO, well, let me step back. TROs now are starting to look a lot like preliminary injunctions, and preliminary injunctions are immediately appealable. And so it really shouldn't matter what label the court puts on it, whether they call it an administrative stay, a TRO, or a preliminary injunction. If the court is enjoining preliminarily, before a party has proven, before a jury or a judge, entitlement to relief, if they're getting that injunction, it should be immediately appealable, no matter what the label is.
And that would make a significant change in court procedure in comparison to how it's been applied historically.
It would. There is some very recent scholarship out about how exactly it came to be that TROs are not appealable. But given what's happening, yes, legislation to address it would probably be the most expeditious way.
So that seeks to expedite review of some of these cases where judges are issuing nationwide orders. And I want to go back to something that we've heard pretty much on both sides of the aisle today, questions pertaining to executive authority, Article 2 authority, and whether or not that should even be reviewable in some instances, especially as it relates to national security matters. Are there instances to alleviate partisan concerns? And I'm sure as a lawyer, it causes you great concern for the stability of this nation and our separation of powers, that there would be a suspicion of partisan agendas among our judges. That's concerning, correct?
We want our judges to be seen as nonpartisan and applying the rule of law only.
And would there be an instance where utilizing a 3-judge panel might alleviate those concerns?
Thank you, Senator. We have instances of that. There are numerous different kinds of cases where a 3-judge panel, the statutes require that a 3-judge panel is convened, and sometimes it is because the cases are of significant national importance or have some kind of, I don't want to say partisan, but important valence to them in terms of the policy. So we see this in redistricting cases, for example. There are 3-judge panels. So there is a place for 3-judge panels, I think. I will say that I personally don't believe that we should say if someone seeks a nationwide injunction or non-party relief, it goes to a 3-judge panel, because that would give the imprimatur of validity to non-party injunctions. And I don't think they're valid if 1 district judge does it, or 3 or 17. I don't think district courts have that power.
But certainly in some instances that might be indicative that the public may prefer a 3-judge panel for assurance of impartiality, that might be preferable.
Right, or another way to put it is just to make sure that there is greater deliberation among intelligent judicial minds about major issues. So, for example, you could have, in substantive areas, you could say, look, if it's a case about the president's wartime powers, it's not going to go to a single district judge. It's going to go to 3 judges, because we'll get the benefit of 3 times the benefit of judicial reasoning.
And even if there were a 3-judge panel, the need for expeditious review would still be important if it is a matter of great national concern or interest.
I think expeditious appellate review of cases implicating policies of significant national concern is important.
Senator Bray.
Thank you, Madam Chairwoman. I wanted to go ahead and jump in. I know that you all talked about a lot of the issues that I wanted to bring up, but Professor Bray and Mr. Panuccio, I'd like to turn to talking about the Administrative Procedures Act and vacature. And one of the provisions of the Judicial Relief Clarification Act, which I am proud to be a co-sponsor of, amends sections 705 and 706 of the APA to limit relief to the persons before the court. My question to the two of you is, can you discuss the emergence of the APA vacature and in the broader conversation surrounding universal injunctions and the importance of addressing that issue in any legislation that addresses the universal injunction problem that we have before us today?
Gladly, Senator. So the Administrative Procedure Act allows challenges and judicial review of agency action. And there is a vigorous debate among scholars about whether the Administrative Procedure Act should be understood as allowing a separate remedy of vacatur. I don't think there is such a remedy of vacatur. There's no traditional remedy called by that name. You won't find it in remedies casebooks or treatises or anything else. But there's a vigorous debate about that. What I don't think you can really debate is the interaction between vacatur and universal injunctions. So one of the things that we've seen, especially in the Biden administration, is litigants and courts were shifting from universal injunctions to vacatur, especially as appellate courts and some of the concurring opinions from the Supreme Court started to express more skepticism of universal injunctions. And that kind of switch is really important for a legislative solution. It means a legislative solution has to tackle the vacatur problem as well. Otherwise, you're just going to play whack-a-mole, and you're going to stop universal injunctions, and all the same things will be done by courts against agencies, at least, under the APA.
Thank you.
Thank you, Senator. Professor Bray is the expert on the history of this. I will just say that, as he has said, the issue of nationwide injunctions or vacatur is, they're one and the same. At the end of the day, it's the court granting relief to parties not before it. There is the issue of the set-aside language in 706, and I think any legislation that's going to address the issue of non-party relief needs to take that on. To just take on injunctions would then, in most cases, allow courts just to say, well, I'm going to look over here to the APA and do the same thing.
Okay, thank you. Professor Bray, I want to get your response to some of the criticism we've heard for those that are opposed to curtailing universal injunctions. Let's start with the criticism that we shouldn't eliminate universal injunction because it could lead to inconsistency and an inconsistent application of the law around the country, or in some form of, as you have called it, disuniformity. As you've written about, it seems to me that the question is not about whether we have uniformity. It's more a question about at what level our legal system and our court system is such nationwide uniformity actually achieved. And so the process to get there and how we achieve that, I think, is kind of what is at question. What's your view on the question, and what's your response to the disuniformity criticism of limiting universal injunctions? And relatedly, is disuniformity an inherently bad thing?
So I think there's a lot of value to uniformity in the law. The question is how and when and who gets you there. And in our legal system, we get uniformity, but we get uniformity over time. And I think one of the striking things that you see for universal injunctions is they are proceeding on a premise that the first judge, selected with highly intense forum shopping and in a time of high judicial polarization, that the first judge who takes the question is going to be right. But often universal injunctions get reversed or narrowed on appeal. And so there should be no presumption of the first judge to tackle the question is the one who should get us to uniformity. Instead, the right way to get to uniformity is through appellate precedent, which, as Justice Kagan said, is the normal process.
Absolutely. Well, thank you so much for your time.
Thank you.
Thank you, Senator Britt. Senator Klobuchar?
Yep, just two more questions here of you, Professor Vladeck. Federal judges, we were going through NIH and what that would mean if you had to have an individual case in every single grant in every single jurisdiction of the country, which is why we have this ability on the nationwide front. Let's look at something else. Federal judges blocked the administration's funding freeze that jeopardized everything from community health centers to child care to infrastructure to support for law enforcement. Can you talk about the impact if those judges had not been able to issue a nationwide injunction, including on non-parties?
Sure. I mean, I think we would have seen, Senator, overnight, tons of entities that depend upon those federal funds to provide vital services to everyone, just having to close up shop and not being able to provide those services because they don't have the money. And so, Professor Bray is right that the question is uniformity at what point. I think part of what has not been fully explicated in our conversation this morning is that one of the justifications for uniformity earlier rather than later is irreparable harm. And is the notion that but for this kind of relief at this early juncture, Mr. Panuccio has been attacking TROs for most of this hearing. TROs are based on the idea that the harm the party is facing is so urgent that there's not time for the ordinary process. And I think we really haven't done a lot this morning to talk about how these policies are harming people in ways that create, to me, extraordinary justifications for these kinds of judicial interventions.
Okay. Last one. Judges have blocked the administration's plans to empower Elon Musk to rummage through American Social Security information, my words, probably not the words in the lawsuit, and get access to their bank accounts, tax returns. This is all the Doge related looking at things. If judges had not been able to issue a nationwide injunction, what would be the impact on the American people?
I mean, again, it's different story, different facts, same problem, right? Which is, you'd need retail litigation by, every American whose Social Security information has been compromised, or you would need to somehow overcome the insuperable barriers that the Supreme Court has created for class certification. And so, I don't mean to beat a dead horse, Senator, but it seems to me that those who are averse to nationwide injunctions, but not to the notion that the federal government should be acting within the confines of the law, should actually be supportive of reforms that would strengthen the nationwide class action as a procedurally proper and historically precedented device for restraining the executive when the lawlessness is on such a wide scale.
Thank you.
Thank you.
Thank you, Senator Klobuchar. Ranking member.
I want to ask a question of Mr. Panuccio, and I think you addressed this earlier, and I want to make sure there's clarity, at least in my mind, on your response. President Trump's executive orders attacking a number of law firms because they employed attorneys who were involved in litigation or represented clients that he did not approve of. I also understand that he's withdrawing security clearances for some members of those law firms, which of course would impact their client relationship and their ability to do work. What is the impact of those executive orders on the targeted firms?
Ranking Member Durbin, you would have to ask those law firms what the impact has been.
What message do you think these executive orders send to the legal community more broadly?
I think you'd have to ask the legal community more broadly.
I'm asking you. You're with a law firm, and it's not unreasonable to ask you, has it come up in conversation in the last 2 weeks among your colleagues?
Well, it's not what I was invited here to testify about, Senator. I think all of these law firms have the ability, if as with any party in this country, to seek individual relief in a court, as many of them are doing.
Yeah. So you kind of think just routine legal work.
Challenging an executive order, whether it was in the Biden administration or this administration or the Bush administration, has become routine in this country, and the courts are open for those individuals to seek redress.
Professor Vladeck, do you have any thoughts on this?
I mean, I don't mean to repeat myself from before, Senator. I just think that, we should all be invested, and by we, I mean lawyers, law professors, members of Congress. The courts thrive when they are receiving the best possible arguments from the members of the bar. And, I think everyone's going to have their own views on who has weaponized what against whom. I think the notion that we should be getting to a place where the executive branch is openly threatening law firms in contexts in which those threats are designed to prevent lawsuits against the federal government jeopardizes the very accountability that separation of powers exists to protect.
Professor Bray?
I think you need a strong and independent bar to represent the interests of all the people in the United States.
Thank you.
Thank you, Ranking Member. And because we allowed them additional questioning, Senator Britt, would you like to have any additional questions?
Absolutely. Thank you so much. Mr. Panuccio, as someone who worked at DOJ, what's your response to the argument of the universal injunctions are a good thing to help prevent having to relitigate the same issue in multiple jurisdictions?
Thank you, Senator. That's not how our multi-tiered hierarchical court system works. The whole point, the first ground for the Supreme Court to take jurisdiction over a case, the reason it will grant cert, as they say, number one reason they will say is if there is a circuit split. Well, how can we ever have a circuit split if we have a district court, which is lower than a circuit, issue a rule for the whole country?
Right.
The whole point is we have percolation. We have over 1,000 district judges in this country to apply their judicial reasoning. And Justice Ginsburg, it's in my written testimony, she had a very eloquent explanation of why percolation, why getting different decisions from different judicial minds is important. So it is not within our historical tradition to have one judge set a rule for the whole country and have that uniformity. That's not what our legal foundation is built upon.
Absolutely. Thank you so much. I appreciate it.
Thank you, Senator Britt. I want to thank the witnesses for your time this morning. I know this has been a long morning, but certainly a topic that is important to this entire country. All eyes and attention is on this right now, so we are so grateful. I think what we have learned today is there is a very keen interest to address making sure that our judiciary remains impartial and that it is making rulings only in terms of relief as to the parties before it, and that we are encouraging expeditious resolution of these extraordinarily important matters, especially as you have a president that is trying to deliver on promises made to the American people and restoring safety and justice to this nation. So with that, I thank you for your time. I thank you to everyone that has participated in the hearing today. Certainly, this is the people's house, and it's important that we have members of the public here with us as we are debating and addressing these important issues. Written questions may be submitted for the record until April the 9th at 5 p.m. I know certain senators asked for written responses if you're willing to provide them, and with that, the hearing is adjourned.